Okay, good morning, everyone. This morning, we're going to be getting a walkthrough and testimony from the bill's reporter of S36, an act relating to Medicaid payment model for residential substance use disorder treatment services. And so we have Katie here this morning, and we are supposed to be hearing from Senator Hart, who reported the bill for the Health and Welfare Committee downstairs. Okay. Take it away, Katie.
Thank you. Good morning, Katie McLean, Office of Legislative Counsel. I thought I would just sort of step back and tell you a little bit about the conversation that initiated the bill. That might be just as helpful as looking at the words. So there was a lot of conversation downstairs about what is the right length of service for somebody who is receiving residential treatment for substance use disorder with a co-occurring mental health condition. And how do we sort of incentivize providers to have that ideal length of treatment? So there was a lot of discussion about payment models. Right now, we have an expert in the room, but my understanding right now is there is episodic payments, and that episodic payments are for about 14 days. So some stays may be less, some stays may be more, but the episodic payment is for 14 days, which tends to be the average. So you'll see that there's language around sort of thinking through what is the right length of treatment and how do we reimburse providers for the right length of treatment. As the conversation went on, there was also sort of a conversation that cropped up about continuum of care. And the committee was interested to learn what was happening in New Hampshire. Granite State model has sort of various levels along the continuum of care on one campus. It looks like people are familiar with that. And there were folks down in the Rutland area who came and talked about the work that they were doing to sort of have multiple levels on the continuum of care within one campus. So that is the conversation that was happening downstairs that led to this particular bill. With that, let me share my screen.
So related to that, so that this topic is not foreign to us. So I think that, probably several of us around the table have heard, and we've heard in testimony previously when we've taken up substance use services around this, 14-day, 2-week limit. And both Diva and the former commissioner, I guess I say now, of health, testified that it wasn't a hard and fast 2-week rule per se. It was what's medically necessary. And then looking at, again, sort of that step down process, or what's the process if it is deemed to be medically necessary. And some providers at that time, at least, and maybe that's changed, but some providers didn't know how to seek a longer treatment when it seemed to be medically necessary for an individual. So we'll be interested to hear more about this bill and to talk to witnesses. So it is for folks new to the committee, this topic is not new to the committee. Yeah.
A clarifying question, the 14-day period, is that in 14-day increments, like a second period can be authorized for a total of 20
We'll have witnesses from Diva, and we have the Medicaid guru here in the room. So we'll have witnesses about that. And I think that this bill actually probably is sort of speaking to what might potentially could happen or what they're seeking to have happen. So why don't you go ahead, Katie? I just wanted to provide some background that we've talked about this topic in our committee before.
So the first two sections talk about first high intensity residential treatment, then low intensity residential treatment. And there's language about who makes decisions around medical necessity. The third section is a report asking the agency to look at how reimbursement occurs more in depth, and there are some parameters. And then there is some sort of cleanup language that I'll go through. So first, high-intensity residential treatment for substance use disorder and co-occurring medical conditions. AHS is to provide coverage for medically necessary, high-intensity, medically monitored residential treatment episodes to Medicaid beneficiaries with substance use disorder and co-occurring mental health condition when when medically necessary, high-intensity, medically monitored residential treatment episodes are prescribed by a healthcare professional employed by a residential treatment program who is practicing within the scope of the health professional's license, and the residential treatment program is participating in Vermont's Medicaid. So this is giving the authority to make the decision to the provider at the residential treatment program.
Okay, so, this, we're not dealing with private insurance at all.
This is Medicaid.
Right. Did they talk about private insurance at all?
I think we were mostly focused on Medicaid, and also I'm not always in the room.
Yeah, I'm just, okay, we'll ask the senator. I don't know, frankly. We've only heard about Medicaid issues, but I don't know if it's an issue for individuals who are covered by private insurance.
Mhm.
But maybe we can ask the providers about that. Okay.
I did ask a question offline at one point of one of the providers to try to understand the breakdown of what the population served was, and it was more than 3/4 that they were serving a Medicaid population versus private insurance, but I that doesn't answer your question.
Yeah, no, it's helpful information though. Thank you.
Subsection B, coverage provided under this section shall be for the entire length of stay prescribed by the healthcare professional employed by a residential treatment program, who shall take into account current best practices for each level of care within the substance use continuum of care.
This might be a better question for Monica, but is this level of care prior authorized by the Agency of Human Services now? Yeah. Monica can ask you that question. Okay, it is. So this would be sort of sidestepping the prior authorization for continuing care.
Potentially.
Yeah, okay.
The next section is low intensity residential treatment for substance use disorder. You'll see that it very much mirrors the language we just looked at. AHS is to provide coverage for medically necessary low intensity, clinically managed instead of medically monitored residential treatment episodes to Medicaid beneficiaries with a substance use disorder and a co-occurring mental health condition when medically necessary low intensity, clinically managed residential treatment episodes are prescribed by a healthcare professional employed at the residential treatment program, is practicing within the scope of their license, and the residential treatment program is participating in Vermont's Medicaid program. And we have the same language in subsection B. Coverage provided under this section is to be for the entire length of stay prescribed by a healthcare professional employed by a residential treatment program, which shall take into account current best practices for levels of care within the substance use continuum of care. So then we move into the report back, and this is sort of looking holistically about how reimbursement for these residential services should be structured. This directs AHS to conduct a review of the Medicaid payment model for residential substance use disorder treatment services, with special consideration given to the actual cost of providing residential treatment services, commensurate with the length of stay, co-occurring physical and mental health needs, and post-residential treatment service needs. The results of the review come to the policy committees on or before December 1st, and the review shall include recommendations and proposed legislation to align the Medicaid payment model with the clinical needs of individuals receiving residential substance use disorder treatment services, and ensure coordinated transitions between residential substance use disorder treatment providers. So that's the continuum of care, the transition between the stages of care. Transitioning from there, the next two sections go hand in hand. Right now, there's a long history of language. Oh, you're familiar with this. With language about it's language that hasn't taken effect yet that would prohibit public inebriates from being incarcerated in a DOC facility. And there's language that has been enacted, but this language about being incarcerated in DOC's facility hasn't taken effect yet. Almost every year or every 2 years for the past 12 to 15 years, the sunset, or not the sunset, but the implementation date of this is pushed out and pushed out. So much so that we had to have a chart at one point to figure out which statute was accurate about the dates that were pushed out. And we started amending it. Anyway, long story, but it has become very complicated. The proposal here is to repeal that language that hasn't taken effect yet. So that's what's happening in section 4, and section 5 is a corresponding change to sort of strike through language that would authorize that language taking effect July 1, 2025.
Okay.
I should
I'll
say.
need more background on that.
Yeah.
Because I
This-
don't understand that.
This is a request from the agency.
Uh-huh.
It's also language that is moving, I want to say in the miscellaneous judiciary bill, and it was asked that it move in both bills to improve the odds of passage, I suppose. So you'll see it in 2 places.
Okay. Okay, I realize I'm asking you questions that probably are better asked of the other witnesses, but how does this public inebriate deal, how does this connect with the community-based public inebriate program run by designated agencies?
I am not the right person to answer that.
Enough.
Yeah, well, and they actually discontinued the one in Chittenden County.
Right, exactly.
Yeah.
That's part of why there aren't enough.
Yeah.
So I
Um,
bet the hospitals want this repeated.
Okay. Okay, that's helpful. Would anybody else have any other questions for Katie about the actual, like, words on the page? I'll need to know more about this, obviously, this public inebriate stuff. The other stuff we're more familiar with. And obviously we'll need to be talking to judiciary as well. Which we might just punt to them. Maybe not, I don't know.
It's
So
a huge public health issue.
it is, yeah.
Don't-
Okay. Thank you, Katie.
You're welcome.
Senator Hart. Hello, good morning. Welcome to House Human Services.
How are you guys today?
We're well. How are you doing?
I'm doing pretty well, actually. This bill's pretty important to me. In my past history of losing my daughter to opiates, so this was kind of important to me. So,
Yeah, we will.
there was a couple amendments that we had.
Senator Hart, because this is your first time in committee, what we typically do is do introductions.
Some of them already.
Yeah, you probably do. But I'm Teresa Wood from Waterbury. I also serve Bolton, Buellscore, and Huntington.
Ann Donahue from Northfield and also Berlin representative.
Good morning, Dan Noyes. I represent Wolcott, Hyde Park, Johnson, and Belvedere.
Last week.
Good morning, Senator Eric McGuire, represent Rutland City.
Brenda Steady, East Milton, Westford.
Doug Bishop, Colchester's Chittenden 20 District.
Zan Eastis, Guilford, and Vernon.
It's Nicola Parker.
Hey, Julie McGill, I'm from Bridgeport, and I also represent Middlebury, New Haven, and Weybridge.
I'm Ray Garofano. I live in Essex. I also represent Essex Junction.
I'm Lori, Community Assistant.
Well, good to meet you all again.
Great, Ray.
Oh, we're representing the Vermont Medical Society. Monica Ogilvy.
I met you.
Yeah. We know Katie, we just heard.
Okay.
Hi, I'm Cecily. I'm interning with Stats and Redford Consulting.
Okay.
Great, thank you. So Senator Hart, introduce yourself for the record and we'll get going.
Yeah, Senator Larry Hart from Orange County. Took over seat 4 this last year. Okay, the S-36 is just the act relating to the medical coverage of long-term residential treatment for co-occurring substance use disorder and mental health conditions. There was a couple amendments asked for from Senator Phil Baruth that we changed a couple of things, and then we also had to change from Senator Lyons asked that we do it in section 1 where it says high-intensity residential treatment, substance use disorder, and co-occurring mental conditions. It says the Agency of Human Services shall provide medical necessary high-intensity medical monitoring resident treatment episodes to Medicaid beneficiaries with substance use disorders and co-occurring mental health conditions when high-intensity medical monitoring residential treatments episodes are prescribed by a healthcare profession employed by a residential treatment program who is practicing within the scope of the health professional's license and residential treatment program and participating Vermont's Medicaid program. At one point, it was up to 14 days. Now we put it up to what is necessary because you can't get recovery in 14 days.
Oh, wait.
There's no way. So it's up to whatever's necessary. So it's up to 180 plus if necessary, whatever it needs. There are some different programs in the state of Vermont that were, for instance, Teen Challenge, which is a men's program up in Johnson. They're a year and a half. So then you've got, they just created a Teen Challenge for women in Hardwick as well. And then you've got Jana's Promise, all these great programs. Yes, Greg and Don do a great job on their program there.
Yeah, I'm sorry. Yeah, we just want you to be able to get through your comments and then we'll ask questions.
Yeah, and then we do have one section 2, if you want me to go on to that one.
Yes.
Low intensity residential treatment for substance use disorder and co-occurring mental health. Again, the wording was changed a little bit by Senator Lyons. The Agency of Human Services shall provide coverage medically necessary for low intensity clinically managed residential treatment episodes for Medicare beneficiaries with substance use disorders and co-occurring mental health conditions when low intensity clinical managed residential treatment episodes are prescribed by a healthcare professional employed by a residential treatment program who is practicing within the scope of the healthcare professional's license and residential treatment program and participating Vermont Medicaid program. And this coverage provided under this section shall be for the entire length of the stay, which is what we changed the wording on. So that's from 14 days to whenever necessary. Prescribed by a healthcare professional employed by a residential treatment program. We shall take into account current best practices for level of care within substance, whatever. So there's that part of it. And is there questions?
Thank you. Representative Shetty.
How about correctional centers? Will they be able to take advantage of this? People that
Yes.
are in a correctional
Yeah,
center
what they're
that,
doing is they've got people from the recovery centers are going into the.
because I know
But right now, they're all pretty much, they're treated with Suboxone more.
I
than
know,
anything.
but
So they're addicted to the.
I mean,
Suboxone.
they panic. As soon as they find out they're gonna be in a correctional center, they go into panic mode.
Yeah, exactly.
Yeah, and that can be very dangerous.
It is very dangerous.
I know.
My cousin was a counselor in a prison in St. Johnsbury. And he said that people would come in there.
They freak out before they know.
They freak out and they were very physically abusive and everything else toward him. He was able to, being an old retired Army guy, he was able to control it. Couldn't get-
Okay, I was just wondering
Yeah,
if this
it's-
would
it's difficult.
extend to the correctional
It is,
centers.
it is difficult. for
So
them.
they would be able to get help?
They'll get help, yes.
Okay.
Yeah, they'll be able to get the help that they need. Yeah. Yes, sir.
So these are relatively new issues to me.
Yeah.
On the surface, I very much like the idea of having a longer treatment period. It seems appropriate. I've heard from constituents and others with who focus on these issues with concerns about the limited nature, 14-day period. I have to think, though, that there is also a bit question of availability. If people are staying longer in treatment, which seems medically appropriate, we only have so many options, so many beds for people. Was there much in the way of testimony on?
We did get testimony from the recovery home in Burlington. And they had quite a few beds there.
Okay.
I don't know the exact amount that he did say because he was talking very fast.
Yeah.
But so there is quite a few beds there. I mean, and then you have the other programs, you know, like I said, Teen Challenge, they have beds. They have like a lot of them. But again, that's a Christian-based treatment center. And then you've got Janus Promise. They have resources.
Good to know.
And they have the resources as well. When I lost my daughter in 2016, she was 8 months pregnant. She died, her baby died from fentanyl intoxication. And so I couldn't save her anymore. So I went on to become a recovery coach myself. And I figured I might be able to save somebody else's kid because my daughter was gone. And it isn't a day that doesn't go by that I don't hurt. You know?
Thank you for sharing that.
So, but I worked very hard. Right now, I don't work for the state of Vermont recovery system. I still am certified in bereavement. I'm certified in family emergency room, recovery. I'm a life coach as well. So I help people through other issues. And but right now I'm currently a sober coach. In other words, if somebody calls me, they have my phone number, they've had it for 6 years, 7 years. They call me and say, hey, I just had a moment. I feel like I want to go I want to go buy, whatever. Okay, let's talk about it. We'll talk on the phone. We might be on the phone for an hour, but we talk about it. And when we get all sudden, I'll ask them open-ended questions. Never ask a yes or no question. Always ask an open-ended question. And if they don't answer you, then you reword the question in a different way that's open-ended, and then they'll have their aha moment and they'll say, I don't want to use tonight. We're not going to use tonight. I'm not going to go buy that drugs down on the street. I'm not going to go to the liquor store and get that alcohol. So it just takes compassion, empathy, and understanding that the addiction is there. We just need to find the resources to help the people with it. You know, and that's right now, again, I'm not working for the state of Vermont, but if somebody calls me from White River Junction, Heartland, that area, I instantly will refer them to the turning point in that area. Burlington, same way. I've had people call me in Burlington.
Nice.
Go see the turning point. They have the resources. They'll work with you. You know, that type of thing.
Yeah, go ahead.
So
And then,
No.
yeah, no, so Donahue and then Cole.
if you're a Northfield person, please go. I love Northfield, by the way.
All right.
My friend's a minister over there, Paul Capaglia.
Oh, he's wonderful.
He's
He's great.
my mentor. He's the reason I do what I do. He's been my mentor from right away.
Yeah, I was wondering about what discussions took place on the last two parts of the bill, the repeal of the inebriate correctional facility.
I don't believe we had any discussion on that, to be honest with you. I think it was all basically, let's get this bill through and get it so we can help people, especially with the mental health disorders and with the substance use disorder. But I don't believe we did. Katie might be able to address that more than
I
I.
don't remember much conversation on these two provisions.
Yeah, I don't either.
Because it's sort of counterintuitive to
Yeah.
helping people and the public health perspective on.
I mean, we did have some really amazing guest speakers too. I mean, we had, we had Katie there, Alex McCracken was there, Jenny spoke. We had Don Tatro spoke on Zoom, and Don and I have a common denominator.
Mhm.
Fortunately, we both lost our daughters. The day that I met her was the last day the day that I graduated from Recovery Vermont with my certificate for that. And I took her to lunch over at the plaza. And I handed her a check for $3,000 to help her cause. And then I reached in my pocket and I handed her a jasper stone that I had, a heart-shaped jasper stone.
Oh.
And I said, any time that you need this jasper, you have a moment of grief, hold on to it and let the power of this stone help you through it, because that's what I've done. She said, I can't take your stone. I said, you did? Yeah, you can. I reached in my other pocket and I said, I had two. So Dawn has my stones to this day. She still holds that stone. Because we did have a common denominator. We sat there, had lunch in tears, both of us, telling our stories to each other. And it wasn't easy, but it was great. But yeah, we had Monica Ogilvy from Human Services, Mark Redmond, Spectrum Youth and Family, Jenny Samuelson from the Agency of Human Services, Chris Smith from Spectrum Youth and Family Services, Chad Vigor from the Recovery House. He's the one that came and really passionately spoke about the need for longer terms for help. With Kelly Daughtry, Commissioner from the Department of Health, Tony Folland from the Clinical Service Manager and State Opioid Treatment Authority, Candace Gale from Vermont Foundation of Recovery. So we had quite a few people come and speak, and they were all in favor of S36 and extended the time out. So that's what and because you can't do it in 14 days. My daughter did it in 14 days and then came out, and a week later had to go back in for 14 days. And then she actually went back to them and asked if she could stay in for 45 days. And they actually approved it. Medicare approved it for 45 days. She came out on January 1st of 2016, was doing well, got back together with her boyfriend. They had a child together already. She was pregnant with another one, and just went to get Suboxone on the day that the clinic was supposed to be open at 8 o'clock. She went there at 9:45. They were closed. She went to a friend's house. They gave her some heroin, and it was not heroin, it was fentanyl. So I got the phone call at 3 o'clock in the afternoon that my daughter was deceased. I never cried so much in my life as I did that day. So, but then I had to toughen it up, and I never took care of myself. Never took care of myself. I was taking care of my ex-wife, my kids, everybody, her kids. I was taking care of family members because I'm the dad. I'm supposed to do that, right? So it took me a year and a half before I called Paul Capeglia and said, I need some help. I'm grieving too much. And he got together with me, and again, an amazing human being, as she knows. Paul is just a great human being. And he's from North Boston, and he's got that little edge to him, and he's not afraid to tell you in layman's terms, even though he's a minister, where the bear pooped in the woods. He might sometimes not say poop, but he's also a good, great guy. And he was the guy that helped me through my grief. And the following year, I was having a moment. I pulled over side the road. I was driving. I called him up and I said, and he said, you know what, Larry, do your recovery stuff. He said, be like that guy on Heartbreak Ridge, one person at a time. Just stay strong, be one person at a time. And that's what I do, one person at a time.
Thank you, Senator Hart.
So that's my testimony. S36, we'd love to have you guys be able to look at it and help pass it through. And if we can get it through to the governor, I know that he's listened to my testimony as well. And I'm sure that we'll have no problem getting it through because he understands too that 14 days is just not enough.
No.
Did you have, I didn't hear anybody from Valley Vista on your witness list.
No, they did not come in.
Okay.
They did not come in.
Okay.
Yeah, there's two Valley Vistas, one in Virgins and one in Bradford.
Yeah, the Virgins one's closing.
Oh, is it?
Yeah.
Yeah, Bradford is still open, but there's still a 14-day. If you request it and they're going to get the funding from Medicaid or Medicare, then they'll stay open they'll have you there for a longer time here. You know, like my daughter requested a longer time because she needed it. And then her ACEs were full. You know what ACEs are? Basically, he does right over here, right? You know what ACEs are? ACEs basically is you have different effects all the way up through. I mean, I did not know until January of 2016 that somebody in my family had molested my daughter. I did not know that. And I found out, and I wasn't afraid to confront.
The average child experiences.
Yeah.
Is that what you're talking about?
Yeah.
Oh, okay. I was,
She had ACEs. She had that. She had ACEs.
yeah.
She was in a bad car accident. She was the driver with with her twin sister. And they both went to the hospital, and I found their vehicle upside down, but nobody was there. And I went into high-speed wobble, and state policeman grabbed me, held me down and said, "They're not here. That's a good thing." What they'd done is they crawled up to the road, and my friend's wife, who's a registered RN, stopped, put him in the car and took him to Cottage Hospital in Woodsville.
Mhm.
And then the fire department came along, said it just came over to dispatch that they were at the hospital. So one of the firemen put me in their vehicle and brought me down. So, because they didn't want me driving. So
Understandable, right?
that was one of the second ACEs. And then she had been sexually abused by a friend of hers.
Mm.
So that was the third ACE. So there was a bunch of ACEs as time goes on.
Mhm.
When you overload with ACEs, then you start turning to something else. And her friend introduced her to, plus the hospital. She played softball and she hurt her knee. And so the doctor, instead of fixing her knee, put her on opioids. And she got addicted to them because they kept feeding her painkillers. That's what she got addicted to. And then they stopped. So she went local to the streets and got painkillers. And that's what caused her to get into what she got into. And so we had a hard time in the good battle, but we battled hard. I've never battled so hard in my life to help her through those moments. And then I talked with her on November 1st for 2 hours on the phone with her. We talked, said we loved each other, everything else. I said, "Hey, I'm here if you need me. Give me a call tomorrow if you're having a moment, whatever." She said, "Okay." I never got the call, but then I got the call. So opioids are not good. We need to somehow figure out what we got to do to fix this state, whatever we got to do. And fix the people. We have to have enough compassion to do it. This bill helps. This bill helps a lot. And I'm glad I signed on with it because it was something that was passionate to me. And the reason that I have the committee that I'm in is because, Senator Baruth read my bio. And he said, "This is where you need to be.
Mhm.
You need to be in health and welfare, and you need to be in government operations. You're a Marine. You're an old Marine. It's a good place for you to be, is over there. And health and welfare, after reading your bio, I think this is the best place for you to be." So I was very happy. Phil and I shook hands on it and everything else. So, I'm a Republican, he's a Democrat, but we still get along.
Thank you so much for, sharing so much of your story here, Senator Hart.
The S-36, if you guys can take a look at it, if something you have any questions, Senator Lyons is more than happy to answer any other questions as well. I couldn't ask for a better chair, to be honest with you. She is very open and very, she's compassionate. She's compassionate about the medical field and especially this. So, but again, if you have any other questions, everybody knows how to get a hold of me. So I'm the guy floating around with an autism shirt.
I noticed that, your tie already. I did notice your tie already.
It's National Autism Day, and it's also my stepdaughter's 21 years old, and she's autistic. And she's graduating from Putney College in a month and a half down to Landmark.
Nice.
And which specializes in autism.
Mhm.
She's highly functioning autistic. They used to call it Asperger's, now they call it ASD, autism spectrum disorder. They changed the name, and she's very theatrical, very musical. I bought her a really nice piano, upright piano for $500. I didn't realize when I opened it up, it was an 1893 Steinway, completely rebuilt. And I got it for $500. So she plays the piano. My wife plays the piano. I play the piano. I play the 12-string guitar, 6-string guitar, play the violin, fiddle, whatever. So we're a musical family. And I can't sing for Pratt, but she can. So thank you so much.
Senator Hart. I appreciate it.
All right, thank you. All right, guys, take care of yourself.
Thank you.
All right, take care.
You guys take care. You stay out of trouble.
I shall.
Yeah, I don't know.
We try to keep them
Lined up
all
here earlier. We tried to
You
keep
take the world of them. I do already. We had lunch together many times.
Yeah.
My mom would disagree.
Yeah. All righty. Thank you. Okay, folks, so we are, I see one of our witnesses arrived early, and so we're a little bit ahead of schedule. Are you ready to go, Mary Ellen?
Sure.
Okay, that would be great. So we're gonna move from that into H92. This is regarding Human Services Board Fair Hearing Proceedings, and we are first going to hear from Legal Aid. So welcome.
I do have PowerPoint. It's short.
Did you send it in?
I sent it in yesterday afternoon, but I might have been too late.
Yeah, but I need to send you the link so that you,
Yeah,
do you have the Zoom link or no?
no, I don't have the Zoom link.
Yes, it is. Thank you.
And I do have copies of my comments, although I'm not sure of them. You want paper copies of the comments?
I don't know if anybody, does anybody want a paper copy? We have it on our,
Okay.
Take
The only thing that might be helpful is that the old memo on expedited process is on the very back. I don't know if that's helpful for the committee to look at.
okay, actually, I'll take one now that you said that. Thank you.
I mean, it's still in the rules, but it's dated 1986, so it's like,
Oh, gee.
yeah. Sorry. I'm gonna turn that off.
Just let us know when you're ready.
Okay.
You should stop the audio when you're.
But do we want to get rid of that, or is that, it doesn't bother them?
Let's go to slideshow.
Let's just wait, do this first, like.
And get it this. Repeal.
Yeah.
It's not, it's like the reverse.
The reverse.
But also that creates problems.
Yeah,
So that's
I
how
didn't understand your comment because I thought it was the reverse, but
Yeah, I thought
Yeah.
if it was repealing, it's not repealing.
Yeah.
Like, so, yeah.
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 and they didn't take any testimony on it.
Right. which-
And they didn't hear from Valley Vista.
Right.
That's the residential.
And Virgin's that just is about to close for one.
There's one more, but I can't remember the name.
I'm not saying it doesn't need to
Yeah.
be addressed, but.
And I thought.
Ready, Meryl?
Yes.
Okay, thank you. Thank you. Welcome. You've been here before, so we'll dispense with introductions and welcome today to give us your thoughts about H92, which is really just a short form bill. So we're interested, and hopefully I haven't had a chance to look at your PowerPoint, but we are really interested in your perspective about how the Human Services Board functions, how your clients view the Human Services Board, and what any potential changes that you think would be beneficial to the operation of the Human Services Board. So each witness, we're asking them for any specific potential changes to the underlying statute of the Human Services Board, if you have any, to please forward them to us for consideration. So thank you. The floor is yours and welcome back.
Thank you very much, Sherwood. Thank you to the committee for having me. My name is Mary Ellen Griffin. I'm a staff attorney at Vermont Legal Aid. And I am here to give our comments on H92, but I'm going to be mostly focusing on the emergency housing program. And certainly if you have questions, feel free to interrupt me. Otherwise, I'll proceed. So first I want to start off with the kinds of cases that Legal Aid sees. Legal Aid recently, actually it was Legal Services Vermont recently completed the legal needs survey, and the comments, both the data and the comments that we got from our community listening surveys were that there is a big unmet need for legal help for people experiencing homelessness. Last year, we got in 2022, 2023, that was when the legal needs survey was. We had 708 calls asking for help with emergency housing and 3,278 pages views of our website on that topic. But we could only represent a fraction of those people just due to limited resources. So we closed 63 emergency housing cases, which included 13 administrative agency decisions and 8 negotiated settlements. In addition, we also represent people at the Human Services Board in many other contexts, including disability services, food stamps, Medicaid. We probably represent maybe 20 people through the entire fair hearing process, all the way to decision per year, and probably another 15 or 20 that we resolve beforehand. Yeah,
go ahead.
I'm here. I'm just trying to understand what you mean by administrative agency decisions when you say you close these emergency housing cases. What does that mean exactly?
So that's a code in our closing. So I had understood the committee wanted to know how many cases we had. So some of these are estimates and some of those are actual data. So when people close cases at Legal Aid, 13 were marked administrative agency decisions. There were 13 emergency housing cases that were closed as administrative agency decisions. So I think those are all Human Services Board decisions. We don't have that many that go to final hearing for one of the reasons that I'll talk about later. And I believe Brenda Siegel mentioned it as well, that one of the biggest issues is that if we prevail at the hearing officer stage, we don't get a final decision. And so that's a problem. And it's always sort of, well, was that by agreement? Because after the hearing officer said that they were going to rule for us, the case goes away.
And so the precedent isn't set.
So the precedent isn't set.
It's hard to capture the data.
Yeah.
Right.
It doesn't come into the report that comes to the legislature. It doesn't go to their library. So I'll skip to that slide. So actually, I took a case to the Supreme Court last fall on this issue because the statute says that the Human Services Board, that the hearing officer decision shall go to the Human Services Board and they shall approve it unless there's good cause not to. And they wouldn't. They said, no, it's moot now because your client has had relief. In fact, in that case, it was a period of ineligibility. And so by the time we got to the Human Services Board, the period of ineligibility would have expired anyway. So there was never a way to get to the point that she shouldn't have never had a period of ineligibility. It was disability related conduct from the start. It got undone at the hearing officer stage. We went to a hearing. We had multiple witnesses. People were sworn under oath. The hearing officer considered everything and said, no, she didn't actually break any rules. She was upset, was consistent with her disability. She didn't actually break a rule. There should be no period of ineligibility.
Mm-hmm.
So we get those cases a lot at Legal Aid, right? Where's the line between, okay, you were upset, you have a disability, where is it like, no, you violated the rule, you threatened people, you're subject to consequences for that, or no, you were, upset. That's okay. People get upset when things happen. So we never get a final decision. And the Supreme Court said, no, it's moot. It's moot because she got housed after the initial hearing. So we're asking the board to change that. And I did put language, sorry, I'm jumping around in my presentation, but I did put language in the end, suggested language to add to the bill to say, even if there's a decision that is favorable to the appellant, that goes to the Human Services Board. If either side wants to correct it or wants to, fix something, the Human Services Board, I think in almost all those cases could just stamp approved. And then it would go into the library. It would be precedent. It would be something for the legislature to know about. It would go into the statistics. But more importantly, the next time an advocate, legal aid, or another advocate gets a case with a similar thing, say, oh, no, we have a decision that says, what is the standard for like, when does your conduct cross the line? Or,
Well, in fact, we asked that question yesterday of the Human Services Board Chair, and the Chief Hearing Officer was here as well. So I was actually a little bit wondering, because it didn't seem like the Human Services Board actually does take that kind of action. So they might see like, okay, well, I remember a case like this, but I'll just use DCF because that's the one we've been talking most about. But it happens in other departments as well, where sort of a similar case is brought multiple times. I forget what he called the person, but the person who brings the complaint, the appellant, I guess, the person who brings the appeal, it was found in favor of that person several times. And so, but the department just continues with their same actions. And I'm like, well, is there feedback? What's the feedback loop back to the department is saying, okay, you're clearly not acting according to your own, because, what the Human Services Board is supposed to do is to review the department's or the agency's own rules, regulations, and say, are you acting in accordance with your rules? And if you're not acting in accordance with your rules, then we're going to find in the case of the appellant. But if they do that several times in a row about the same or similar situation, there is no feedback loop saying, they have no authority to suggest to the department that, or to AHS, maybe to the secretary's office, there should be some sort of corrective action. There should be some sort of, whether it's additional training or whether it's, understanding how to implement your own regulations. And that's one piece that I found troubling yesterday, that it just so, it feels not respectful of the individuals who are seeking or receiving the supports or services, particularly when a department is not following its own rules, and that's been determined several times by the Human Services Board. There has to be something different in place so that people don't continually be subjected to that, those errors. Okay. That was a little bit of a soapbox. It's not efficient and it's not humane either.
Yeah. The other problem that on top of that issue, that is the main issue that I wanted the committee to realize, but you already know about it, is that if the department prevails at the hearing officer stage, typically the appellant will appeal to the Human Services Board, and typically the Human Services Board will approve what the hearing officer said. So then all the decisions look like the department wins all the time. Those are the only ones that get reported. And so it's not a balanced picture of like, sometimes the department's right and sometimes the department's wrong. And like advocates, the department, the legislature should all be able to see both sides. Like, it just helps to move the process forward and like you said, the feedback loop to improve the whole program.
Thank you.
Oops. So sorry. Not that good at. Oh my gosh, what just happened?
Okay.
There we go. About that. So, I mean, the main point so far of H92 is to improve access for self-represented appellants, and we certainly support that wholeheartedly. We support regular meetings between legal aid and the Human Services Board. We have had some, but we don't have regular. We've talked about with them about trying to set up like a legal clinic where we could just, it used to be when you would go in person, we could go sit in the hall and try to pick up people as they're going in and say, do you want someone to sit with you? I could talk to you for 5 minutes before you go in. So we'd be open to trying to set something up like that electronically to say like, you can get us the cases and we'll try to talk to as many people as we can. We do that like in rent escrow cases. Sometimes go to the court and just get people before the case and say, do you want legal advice? We'll try to give you some legal advice, try to settle your case. We support the plain language requirement in H92.
He has a question.
Oh, I'm sorry, I didn't see it.
Question,
I
but
didn't see
yeah.
it. Go ahead.
A question about the point, about regular meetings between legal aid and the Human Services Board. When you're referring to the Human Services Board in that instance, are you thinking specifically of the board members or of hearing officers and other paid staff?
Thank you for that. You're right. I think the most useful time would be before the hearing officer, because often if someone's going into a hearing alone, like this committee has heard, it's challenging to handle some of the procedural issues. And so maybe having someone to talk to before or someone to sit with you at the hearing could be helpful. So that's where we would most want to do some sort of clinic-y connection with the Human Services Board to pick up some of those cases.
Mm-hmm. And are you, I guess I'm asking, are you saying that you can do that within your existing resources?
That was my question. How does that work with the resources?
Yeah.
That's a little bit above my pay grade, but I think we could do some. I mean, because the clinic ones are shorter. So we can do for an intake where we would prepare it and put more hours in. We're certainly limited in how many of those we can take. But talking to people, giving quick advice before the hearing, we can do a lot more people.
Mhm.
It's just, it requires, because it's all electronic and now it's all on Zoom, maybe it's not all.
Oh, most of it, you
Most of
said,
it.
yeah.
It's just harder to find the people and to say like, can I talk to you for 10 minutes before your hearing?
Right.
And some of those, maybe we'd walk in with people or some of them we wouldn't. I mean, we'd have to work that out, but it would require coordination with the Human Services Board to say,
Mhm.
can you block schedule them? Or could we somehow, I don't know.
Yeah.
But certainly the quick advice, I think we could do a lot more good for people, a lot more people that way.
Mhm. Mhm. Okay, thank you.
And we do recommend, we remain concerned, however, that the Human Services Board hearings are still very formal and multi-step process. It's very confusing. It is, the first time I did one, it is very confusing. The status conferences, when's the hearing, what are the rules? So we would recommend that the Human Services Board provide more comprehensive, plain language instruction for people about how the process works. The fair hearing summary document, which I noticed that Hearing Officer Reiner presented. I hadn't seen that. Maybe it was on there all the time. I just hadn't noticed it, but I think it could be reorganized to be more clear and to be expanded to explain the key steps and the key terminology. There's even like appellant, status conference, discovery, like what all those words mean. And the difference between a recommended decision of the hearing officer and a decision of the Human Services Board. So my other big recommendation for emergency housing appeals is to put into statute the expedited hearing process. I think this committee's heard from others already that in practice, the hearings are expedited and we don't have complaints about the Human Services Board. The Human Services Board has done a lot to try to have those hearings go quickly. But most cases, people aren't getting emergency housing pending an appeal. So somebody's out on the street. There's now a rule that you can ask the hearing officer to order benefits pending, essentially. Especially as we've seen it sometimes when someone is in housing, is being terminated and is appealing, but it's not clear what the standard is. So anyway, everybody needs those to be resolved quickly. Whether somebody's in housing and you want to get them out, or they're not in housing and they need to be in, that needs to be resolved quickly. I don't think anyone disputes that they should be expedited. The biggest delay that we have seen is getting the records from the department. And that delays both having the hearing with the hearing officer and resolving the case by agreement. We've worked with the Attorney General's office. It's a couple of attorneys at the Attorney General's office that we have a pretty good relationship with. And often if we get the record, the attorneys can have a conversation and resolve the case.
Mm-hmm.
It's hard to know sometimes what's going on without seeing the record. So our recommendation would be the same or next day supervisor review that's in the 1986 memo, which is on the back of the comments. It was district director review, but it doesn't, that position doesn't exist anymore, and we haven't seen the same or next day supervisor review happening. But some kind of review internally that day, somebody puts together the packet, gives it to their supervisor, the supervisor looks at it, says, yes, this is right, no, this is wrong. And then that record immediately goes to the Human Services Board, the appellant, their advocate or attorney if they have one, and the Attorney General. And then we can all get ready for the hearing.
Yes, or there may not have a need for a hearing if it's
Right.
stalled,
Right.
right? Yeah,
That would be nice.
yeah.
We would ask that the hearing officer issue a decision within 5 days, which is mostly what they have been doing. It just makes me nervous relying on the good faith of the current hearing officers who are working really hard to get these cases heard quickly. I don't know that will always continue, so it's good to have that in statute.
Okay.
And right now, I think it's sort of to split the baby if people are out while they're waiting for these decisions. Once the hearing officer makes a ruling, if it's favorable to the appellant, the person seeking housing, the department will immediately implement it. And they do that. That's in their rules, and that we have seen that happen. So you get a hearing officer decision, it says, no, this person has a right to emergency housing, they should be in shelter. The hearing officer, the department will implement that decision. And that should stay in the rule. So while I want a Human Services Board final decision, I also still want immediate implementation of favorable decisions at the hearing officer stage. Because often it takes 6 weeks, 2 months to get to the Human Services Board, and that's just too long.
Yeah, I understand what you're saying. So if they're going to implement it, this still needs to be on record that it was a favorable decision, even if in the end, it doesn't actually end up going to the Human Services Board itself because it's been implemented by the department. There still needs to be a record of that as part of the, I guess what I would call the official record of disposition of the cases. And we heard from the chief hearing officer that they don't always know what's happened. So the case is dropped at some point, and they're presuming that in most cases, the department has implemented, something favorable to the individual. But we don't actually know that. And so that would be helpful data. And as you said, would represent a more balanced picture of what the actual activity of the Human Services Board has been, what the outcomes of that process are. Okay, thank you.
That's all I had for the committee this morning. But if there's any questions or.
I have a question for you. Who is the head of the Disability Law Project now?
Kelly Kazmarski?
Okay. I think I would like to hear from her or Barb Prine or somebody on the disability side of things and the experience on the disability side, which is more often about eligibility. Okay.
I can tell you, I ran into somebody from the Disability Law Project on my way over here, and I said, do you have anything for the committee?
Yeah.
So we chatted a little bit. She said, yes, she has a lot of those hearings. And for her as well, it takes a long time to get the records. She said, that's the delay for us. And for them, it takes, she said she had a case that took months to get the record.
Yeah.
But her client was still receiving services. So it wasn't as big a deal because they're getting services pending the outcome of the hearing, but that the delay in getting the records is really substantial.
Thank you.
I can definitely ask Kelly Kazmarski or
Well, you don't need to, but if you could provide that contact information to Lori, that would be great.
Sure.
Okay.
Glad to.
All right. Thank you. Are there any other questions for Mary Ellen? Okay, great. Thank you so much, Mary Ellen. And thank you for providing specific instances where you'd like to see some amendments.
Stop sharing.
I need to stop sharing.
It's a process, Mary Ellen. Don't worry about it. Oh, I see we have Stuart online. Okay.
Good morning.
I might have to.
Okay, so we got started a little early. Mary Ellen happened to be here early and we got done with our previous witnesses a little early. So we have Stuart Schurer and Jennifer Micah here. I'm not sure which one wants to go first.
Jennifer Micah from DCF. I don't think we actually have a presentation for you. We're
Yeah.
here really to answer questions, so we could do that in the end.
Okay.
Or I think that we, EHS would like to provide additional information next week, but we're
Yes.
not prepared to today.
To do that today,
But we
okay.
are prepared to answer questions.
Okay, great. So Jennifer, why don't you join us? Good morning, Stuart.
Good morning.
Okay, so as you're aware, we're looking at, we're just honestly taking a look at the Human Services Board statute. It hasn't been looked at in totality, sort of the baseline statute for quite a long period of time. And it's a integral part of the experience for people who receive services and the departments who are providing them or providing access to those services. And so we're just trying to honestly get, a handle on the experience of individuals as well as the experience of the departments in, presenting or dealing with the Human Services Board. And as Jennifer just said, I did hear from the agency that they actually are going to have some suggestions for modifications, but not until next week. So that's fine. Stuart, I didn't know if you had anything that you wanted to say. Jennifer says you're kind of mostly here to answer questions, but opening it up to you if you have anything that you want to say in particular.
Thank you. So good morning. For the record, Stuart Scher, General Counsel for Dale. I don't have any prepared comments. I really, like Jennifer, was here to answer any questions. It was hard to decipher from the short form of the bill exactly where you were headed with this. So we just thought it best to be prepared to answer questions as they arose.
Thank you. Well, I'll start off with a couple. I'm just wondering, do you keep records at the department level in terms of the number of cases that you have, the disposition of them, things that are settled before they actually make it? You might have heard some of the testimony of the previous witness, things that are settled before they get to the board level, maybe after the hearing officer piece of it. Do you keep records on the disposition of the cases that you deal with in terms of any kinds of appeals that are brought to you? We'll start with Jennifer first.
Thank you. Jennifer Micah, General Counsel for Department for Children and Families. I do not believe we keep those records, but I will check.
Okay.
We certainly have records of every case that comes to us on appeal, and we preserve them as we're required to do. I think the question is whether we actually have data on the actual numbers and whether we gather that. I believe that we have a lot of that information in spreadsheets, but I don't know if we could sort of just hit a button and say, during this fiscal year, X number of cases were resolved without a hearing. This number of cases went to hearing and were affirmed. We would be able to pull that with some effort by looking probably case by case as to the disposition of those matters.
Okay. So one of the things that's come up actually, with testimony with the Human Services Board and also as we just heard from the previous witness is this, a couple of things that there ends up not being sort of an official record if something gets to the point of, okay, the hearing officer has issued some preliminary findings and they're in favor of the person who's appealed. The department then decides to go ahead and whatever department decides to go ahead and implement that because in most cases, the Human Services Board agrees with the hearing officer. How are those cases handled? Do you consider those to be like official appeals? Are they things that you track in terms of then as attorneys for each of your departments? Do you go back and talk to the program people and say like, okay, well, we've had, 5 cases we brought to the Human Services Board on this one topic, and they've all been, resulted in a favorable decision to the person appealing. Maybe we should be taking a look at what we're doing here. Do you have those kinds of conversations with your program people? I guess I'll start with you, Jennifer, because you're sitting here.
We absolutely have those conversations. And if it appears that the case it appears that we could not prevail in the case because there's a legal deficiency, then we try to change that. Obviously not every time. It's depending on what the reason was, whether it was a fact specific issue or whether it was actually a legal issue. If we're doing something illegally, then we need to immediately change it. And some of those cases flag those things for us. So yeah, we're always having conversations. I'm always having conversations with the AAGs who are actually working the case for DCF, and with the program people who are trying to implement the policies, procedures, and rules in the law.
Stuart, any thoughts about that?
I think I'd have to echo what Jennifer said. We're a little bit different at Dale in that we don't use the AAGs for our to represent the department. We actually have staff attorneys. And I supervise those staff attorneys. So I'm well aware of the matters and the issues that come up. And if there are issues of that nature, we routinely will bring in division directors, program staff. We'll then also talk to leadership in the department if there is a pattern of matters that need to be addressed. If it's one particular case, let's put it this way: we talk about every case with our program staff. When an appeal comes in, Medicaid cases, actually, there's a requirement that there be an exhaustion of the internal appeal. So all of those cases have to be heard at the department level first. When they're heard there's involvement with the commissioner's office, with the staff attorney, and then with program staff after the hearing to understand if there's a way to resolve the case short of going to fair hearing. Because if there's a way to resolve this, if we're fairly close, if we have concerns about where the case could be going, we try to resolve it. And the goal is never to pursue the matter if it can be settled in advance. So we're always bringing in our program staff, discussing issues that come up. If there are legal challenges that span, across a number of cases, we're looking at how those can be addressed.
Okay, thank you. I'm just am thinking trying to ascertain from one of the reasons that this short form bill was introduced is because of experiences that certain people who have appealed to the Human Services Board and the experiences that they had, and which were quite negative. And as we've sort of listened to some testimony, and it is appearing more like the negative experience that people had was a result of the attorneys representing the departments involved, not necessarily the Human Services Board hearing officer. And I'm just wondering, what kind of feedback do you get from the Human Services Board? So if neither of you are the person in the representing the department at that particular time, if it's a different attorney, do you get feedback from the Human Services Board regarding the, potential conduct of any of your staff or the people representing the department at that point in time? We did hear about the Human Services Board having to intervene when it felt like the department, whoever was representing the departments, got overly aggressive, I guess I would say.
Well,
So,
go ahead, Jennifer. Go ahead.
We do not hear from the Human Services Board hearing officers or from the hearing board itself about the conduct of our attorneys, and we certainly would want to know that. That's concerning to me. I hadn't heard that. I haven't had a chance to listen to all the testimony that's on this bill yet. And I did read the notes from Ms. Siegel's testimony. I didn't see that in the notes. So I'd be interested to know what the testimony was, if you wanted to give me a thumbnail of that.
We were trying to be clear of citing particular cases. Mr. Shore.
Yeah, thank you. So we, as Jennifer said, we don't hear directly from hearing officers or the board as to or I don't, I should say, as the supervisor of the attorneys. it could also very well be that there haven't been any complaints about the Dale attorneys. And I have to say that we are attorneys, and our jobs are to vigorously advocate the case. And it's clear that when parties are appealing the decisions, they feel very strongly about their position, and the department, it's an obligation of the department to advocate its position as well. And so it's not surprising that we hear that some people aren't satisfied with the conduct of the attorneys, but I would ask you to consider whether that is truly what the concerns are, or whether it's zealous advocacy on behalf of the department. Because from my experience, I used to do these cases myself, and while I haven't been before the board in a number of years, the hearing officers will give a lot of time and opportunity to litigants. They often accommodate long periods of time where the individual can not only testify, but can raise grievances uninterrupted. And in fact, I know of a situation just the other day where during a telephone status conference, an individual was allowed to go on for 23 minutes talking about how they were just being treated poorly, how they weren't satisfied. The hearing officer let them go on, and then at the end of the 23rd minute said, "I need to take control of this proceeding." And after that was done, the individual went on for another 5 minutes doing the same thing. So the hearing officers, I would say, are giving ample opportunity for individuals to voice their grievances. And I would just be interested to know what specifically the individuals are asserting that the department attorneys are doing improperly. Because if that were brought to my attention, I action would be taken if it were appropriate. But in order to do that, I think we need to understand whether there's true misconduct by an attorney, or whether they're overstepping their bounds, or whether it's simply a litigant who is unsatisfied with the zealous advocacy of the department's attorney.
Representative Garofano and then Representative Bishop.
Thank you. Thank you for both for being here. I'm just curious, we've heard from other witnesses about the desire to connect more with the hearing officers, advocates, legal aid, you folks. So, just kind of thinking about process improvement and like the experience that folks are having with the hearings. Would you consider, is that something that you think about, like to kind of all get together to kind of maybe create some feedback loops, to create some kind of process to evaluate how the system is working? I'm assuming that doesn't exist, and if it doesn't, is that something that you would be open to meet with all the stakeholders on a regular basis, every quarter, come together, talk about what's working, what's not, how can we improve it? Just thinking like for future, be nice to have this, not need to have legislation to have the system improved and have a better experience for the people who are going through this process.
Yeah, I think it would be really helpful. I do think that, in the judicial setting, you have what are called bench bar meetings. And so you'll have the attorneys in the area meeting with the judges in the area and sort of spending time hashing out issues that might be coming up. And those go even so far as to talk about what's happening with the clerks and how to get forms filed and all that kind of stuff. So it's always really helpful. I was an AAG with Dale under your chair, and I had really close relationships, professional relationships with the Disability Law Project, especially Bart Prine and Marilyn Mahusty, and at DCF, it's a much different relationship because I'm not actually doing the cases. But, we were always calling each other, and I don't really see that happening as much. I'm not quite sure why that is, whether it's just the fast-paced nature of DCF's work largely, which is something I wanted to mention, actually, there's a really big difference between how DCF cases proceed and how Dale cases proceed, because those Dale cases are determining eligibility for life sometimes. So you're talking about decades of services. And so Dale often took a very strong position on their rules. There's like, you don't fit the rule, I'm sorry, we can't give you services, because we've got a whole bunch of other people who do fit the rule. And so those cases could go on for a very long time. You would have consultants, you would have, Mary Ellen mentioned the difficulty in getting records. Well, part of that is because some of these people have so many medical needs that there's so many different records to get, and it's not always easy. But at DCF, these housing cases go from, day 1 to day 5 and they're done, or day 1 to day 2 and they're done. And so it's and I can understand the frustration in not being able to get the records quickly. And part of that is just that we're swamped. Like, there's so much going on, and there are people who are trying to manage a whole lot of things at the same time. So to the original question, I do think that constant professional relationship maintenance is actually what it really is really, really important.
Yeah, I would just add that I would defer probably to AHS on the representation in those discussions to talk about process improvements. We at the department level, we're certainly always in a position to work with an individual if they're representing themselves or with their attorney on a particular case. And as appropriate, we would certainly be involved in any discussions around process improvement, with the caveat that as part of those discussions with the Human Services Board, with the advocates, with the departments, that we wouldn't be talking about specific cases, but more general principles. The other thing that I would just mention, and I'm sorry I missed Mary Ellen's testimony earlier, but if there were some comments about delays in obtaining records, and it sounds like there were, I just wanted to say that when an appeal comes into Dale, one of the very first things that we do, in addition to acknowledging receipt of that request and calendaring it and sending a notice out for the internal appeal, which has to be exhausted before we can even think about going to a fair hearing, we also start gathering immediately all of the records that would be applicable, because we need to talk to our program staff to understand why a decision was made at the department level, at the division level. And in order to do that, we have to put together a memorandum. We have to have access to all those records. So a lot of times it's as simple, well, I shouldn't even say that simple. The records are internal. If we're talking about a choices for care recipient, we would likely have all of those records in our system, and it would be a matter of pulling them down. But when an individual has been served by a designated agency or a specialized service agency, we're not a direct provider of services, as many of you know. So we are reaching out to those agencies to get copies of those records to be able to provide that discovery to the individual. And that can take some time. So I just want you to understand that we are not delaying our search for these records, that we realize it's important to get them to the individual as quickly as possible. When a matter finally gets to fair hearing, the process currently provides for one, if not several, telephone status conferences at which discovery deadlines are set and information is shared between the parties. So there is a mechanism already in place for doing that. And I just want to be clear that we are not waiting weeks or even months to get records to people, but there are some times where there are challenges in doing that.
And it's my recollection, at least, that there are in both cases, I'm more familiar with the Dale ones, but that there are actually timelines in rule associated with the appeal process. Is my recollection accurate about that?
Absolutely. Most of the at the internal appeal level, it's the number of days that an individual after receiving an adverse benefit determination has to request an appeal. And then once the appeal is requested, the internal appeal under Medicaid rules must be completed and a decision issued within 30 days unless it's extended for up to 14. Then once that decision is issued, the individual has a number of days to request a fair hearing if they're still not satisfied. And generally, the Human Services Board is supposed to, the hearing officer is supposed to conclude the hearing and issue the findings within a certain number of days as well. Those timelines are often not met, but I do appreciate that they're running into challenges at the Human Services Board with staffing as well. And I fully appreciate that they're working as hard as they can. There are some cases that are required to be handled more quickly than others. And I think that's an area where maybe we need to look at the timelines being adhered to. When someone appeals a Medicaid case and they're getting continuing benefits, they're getting those continuing benefits until the resolution of the appeal. Mm-hmm. And if they ultimately do not prevail, the state has paid continuing benefits for a period of time. So there is an interest in getting resolution to these matters, to know whether that individual is truly entitled to those services or whether those services should have been suspended or reduced.
Thank you. Yeah, and I think that is that differs from department to department, and whether we're talking about a Medicaid benefit or a state-funded benefit, the continuation of services. So that's less detrimental to the individual because they don't actually experience the reduction or change until it's gotten through the process. And that's not always the case in a state-funded service. It's those protections aren't quite as tight.
Mm-hmm.
Individuals. Go ahead, Representative Bishop.
I wanted to return for a moment to the zealous advocacy issue we were discussing a couple of minutes ago. And I'm an attorney by training. I practiced for 12 years. It's been a few years since I have practiced and well understand our training and our duties to our clients with zealous advocacy. I do see that this arena is a little different than the one in which I practiced. In the prevalence of the pro se litigant is much higher and for decisions being brought or cases being brought before the Human Services Board, whether a hearing officer or the full board. Is there any training? It sounds like Dale uses in-house attorneys. DCF uses assistant AGs. Is that correct? Are you, do you provide either at Dale or are you aware of any of the AAGs receiving specific training about working in an environment with pro se litigants?
Not that I'm aware of. I didn't get that when I was an AAG, and I have not heard that our AAGs get that.
And I agree. There's no specific training in working with pro se litigants. But I'm sorry, I'll let you finish because.
No, that's all.
Okay, I work closely with the attorneys that at Dale. I can't speak for the attorneys in other departments, but I have to take issue with any representation that any of our staff attorneys are not treating pro se litigants with the utmost respect, and that is to suggest otherwise is really hard for me to hear because I work very closely with the staff attorneys here, and it would shock me to learn that they were doing something or speaking to someone in a disrespectful manner, or were not acting appropriately. I often hear complaints from folks, however, who believe that they are not being treated fairly, but it is through no fault of the attorney, because as I said, those attorneys, in my experience, have done nothing but to try to accommodate and try to resolve matters and speak with the utmost respect with those individuals.
I guess I would add, I didn't think, and I hope in my question, I did not imply any knowledge of any poor behavior on behalf of the attorneys. I think there's just the nature of the process. We as attorneys are familiar with it. It's the milieu in which we interact every day. We may frame questions. We may approach a proceeding just differently by nature. So even if acting respectfully at all times, it's still, I guess, in asking about training, anything about a recognition that for the others involved in the hearing, a pro se litigant or petitioner, it's just not what they do on a daily basis. They're a fish out of water. So really, aside from even, obviously, we would all, I hope, want to address, and I sincerely hear it in your voice, want to address any disrespect, but I'm just talking more broadly even about process issues.
Sure. And skills, and I thank you for that clarification. I will say that we don't hire folks at Dale exclusively those with prosecutorial backgrounds. We actually have hired folks who have come from the criminal public defense world, who have come from Vermont Legal Aid. So these are individuals who know about consumers, who know about individuals who have been charged with crimes. And so I do believe that while we may not offer them specific training on how to deal with pro se litigants, we have attorneys in my history here at Dale, which is like 14 years now. We have hired attorneys who have diverse backgrounds, and specifically in dealing with people who have been underrepresented or and they do appreciate those unique needs of those folks.
Thank you.
Representative Donahue.
Yeah, thank you. I sort of want to follow up a little bit on that. First of all, on site, I mean, we've setting aside respect, I think there's been a concern raised when it's pro se that there's at least a perception of a conflict of interest. But going back to the training issue, and I assume, you can say if I'm correct, but I assume if there's not specific training about working with a pro se litigant, that there is also not specific implicit bias training, because obviously implicit bias means you're not aware of it and you think you're being respectful and you think you're being responsive. But it concerns me to hear the perspective that people are complaining about feeling disrespected, but there isn't a belief that they are being disrespected. And I guess I've become even more attuned to that than I had been before, because I recently was appointed to the House Discrimination panel, and we've done training on that. And the really important distinction that how people perceive they're being treated, the impact is really significant. And if there isn't specific training about implicit bias and about how it impacts people, even if you don't think you're doing it, seems to maybe be the missing link.
May I address that a little bit? First, I would just like to say, the state requires us all to take some trainings. They're online, they're not very long, but I just want to say we do have to do that. Implicit bias is something that I do raise with people regularly, because I am sensitive to the power that disparity, really. It's really a power disparity between the state coming in with all its money, all its lawyers, all its everything. And this person coming in who, it might be the first time they've ever had to appear in front of a hearing officer, appear with a lawyer, they feel intimidated, they feel out of it. And we're very comfortable with it, right? We do it every day. We get thick skins, we talk loud, we do all these things. And so I try to maintain that sense. And when I talk to the client, I do say, okay, but what are they saying? What do they want? What do they need? You know, you have to, and you have to do it in a way that people can hear you too, because they're proud of their work and they're trying to do what they're told to do. And you have to manage both of those things, right? And so we do work on it regularly. I do. The implicit bias is huge for me, because it is. You don't know. You're not paying. You're not aware of it if it's implicit. So you have to keep asking yourself, is there something else going on here?
Right. I just think from hearing testimony that there are a lot of, that there's an awareness of a lot of complaints from the perception of people on the other end, that sort of suggests that there's a need for evaluating what the causes are, really doing a deeper dive on why there's that disconnect between the perception of being really respectful and recognizing those issues, and yet a lot of folks on the other end feeling it's not happening.
And maybe that goes to the question about pro se training,
Yes.
making sure that you make sure you don't come in as if you're going to be opposing, Skadden Arps, big evil law firm these days. You don't want to come in like that. You want to come in with a different sort of demeanor and a different way of talking.
Well, and even, and this may come back to when an individual or family decides that they want to have an appeal of a decision, and sort of like I guess, more complete understanding of what that means, especially if you get to all the place of the Human Services Board. And I don't know to what extent, most of the rules that I read are not plain language. And so trying to have them be explained to somebody, oftentimes, I'll be honest, even the staff who are trying to implement the rules don't understand them. And I know that organizations like Green Mountain Self Advocates has been really active in, putting together plain language versions of the rules in collaboration with, various state programs. And it might actually be helpful to entertain contracting with them to assist the Agency of Human Services and the Human Services Board and individual departments to explain the rules for appeal in particular, in a more understandable way for individuals, particularly if they're going to find out that, you're representing yourself. Like, I'm not really sure that people understand when they get to the point of the Human Services Board that it really is, pretty similar to going to court, because the next step is going to the Supreme Court in terms of an appeal. And so I understand that naturally it needs to be sort of in that space of being pretty formal. And as Stuart said, I forgot the phrase that you just said, but, representing the department's position. What was the phrase you said, Stuart?
Zealous advocacy.
Zealous advocacy for the department's position, yes.
And that's an ethical obligation.
That's what you're supposed to be doing, right? And I don't think that most people, when they get to that stage, they're expecting that. And so they're expecting these are going to be helpful people to try to understand my situation and help me through this process. And they're not really expecting somebody to be objecting to what they say or objecting to, the facts as they are presented. And I think we need to figure out a way to better prepare people for that situation and better explain it to them. And we have resources in the state that can make that more helpful to people. And I think we should think about how we employ those. And I'm not hearing that, in general, I feel like, so far what we've heard is that, people are acting in representing their constituents, whether that's the department or it's the Human Services Board, trying to make fair and impartial decisions. But, just looking at on the AHS website, you can see sort of a listing of cases and disposition of cases. And it's just, I think that it's important for people to understand that they're entering into a pretty close to judicial kind of situation. And I'm certain from the people that I've talked to that they don't understand that when they get to that point. Yeah.
I would agree with that.
Yeah. Go ahead, Stuart.
Yeah, thank you. So I just wanted to loop back to Representative Donahue's comment. And I think I I completely agree with what was said. I want to be clear that there's certainly no ill intent, and I think that's where I'm trying to go. That we're advocating zealously. It's our ethical obligation to do so. Naturally, when you're in any situation, and it is an adversarial situation, you're going to have people with different perspectives, different expectations, different hopes for the outcome, and so they may not always see eye to eye. I think that there is room for all of us, because there is no intent to harm anyone, to disrespect anyone. There is value in having us understand what those concerns are, why individuals don't feel that they're heard. And so I think that's a really good recommendation. I would say, though, Madam Chair, we have taken steps also to create plain language documents. You may recall that when we last updated the developmental disabilities rules, one of the things that legal aid was advocating was that there be a plain language document. And we, as a department staff, worked with their staff as well to create one. So that does exist. We have forms that DEVA actually has put together, grievance and appeals forms that use that use layman's terms, that avoid all that legalese that can get so complicated. And then, as I mentioned before, there is an exhaustion requirement, especially for Medicaid cases, so that by the time someone gets to a fair hearing, they will have come before, in Dale's case, before the deputy commissioner. They will have had an opportunity to have an informal discussion to understand, to voice their concerns about the outcome that the division made on their case. And then they'll get a very detailed letter explaining to them why the decision was made, what evidence was heard, and then laying out exactly what their next steps are. So we do take great pains to make sure that people understand. And when someone calls in with a request for an appeal, or just maybe they're calling because they're dissatisfied, but they don't use the term, I want to appeal this. It is our role to assist someone with an appeal, to make sure that they get the opportunity to challenge something if that's what they want, but maybe they're not using that magic word. I do talk to my staff and our administrative services coordinator about understanding when somebody calls and when it means that they want an appeal. And so we are constantly thinking about how to make the process more user-friendly, more customer-friendly. And certainly there is room for improvement, though.
Yeah, thank you. Thank you for that, Stuart. And I think that sort of by virtue of the nature of the services at Dale, that Dale is probably, more in tune with the needs of people with disabilities in terms of communication, in terms of interpretation and understanding. And I think that actually maybe it might be helpful for Dale to assist other departments in understanding that, because all departments have individuals who have disabilities who are, accessing services. And so I appreciate that comment. Other questions for these witnesses? It's been very helpful to understand from your perspective and to, really, I think, have a grasp on the that, it is the obligation of the attorneys for the departments to be representing what the department's position is, and, why that why they are there. And at some point in time that the individuals who are bringing the appeal, I still think that we could do a better job in helping them to understand that process and figuring out how that takes place, as well as, looking down through the data points on the AHS website. The point that the previous witness was making about the disposition of cases, and I think that we need some work on that, but that's not your guys' case. So any final comments that either of you would like to make?
The only comment I would like to make is that I do know, because I've been in the hearings myself, the hearing officers do try really hard to explain things to the pro se litigants. And they do try to rephrase things if a lawyer says something in a confusing way, or to explain what a motion to dismiss might mean, or what rights they have. But it can put the hearing officer in an awkward position. And I don't know how to fix that, because when I was doing the cases, it would put me in a situation, because I would want to try to help the person understand.
Mhm.
And I also need to zealously advocate for my client. And so I couldn't do
I'm
anything.
going to use Stuart's term.
I know.
From art.
It needs something specific. Okay, all right.
Yes, it's actually a term, yeah, so,
I have to write it down.
yeah.
Okay.
Zealous advocate.
Mhm.
And so I don't know how we get around that, and maybe something around, like Mary Ellen was talking about, having some kind of hearing or pre-status conference discussion with the client or something. Maybe that would be helpful. I know legal aid certainly would have a very hard time taking all of DCF's cases. There are so many, but that, like, they don't do this every day. So it's really hard. And I really sympathize with that. I mean, the legal system is confusing.
Mhm. Yeah, and I also appreciate the fact that different departments are going to have different reasons for being there.
Mhm.
And the nature of why you're there is going to be very different. Like, I mean, you made the point earlier, at Dale, you're really talking about something that potentially could be a service decision or an eligibility decision that will last for the rest of that person's life, and commits the state to ongoing support and expenses for decades to come potentially. And that's not generally the same at DCF. It's usually more time limited services. So there is a need for the Human Services Board and the hearing officers to have some flexibility in understanding the complexity of those decisions and the speed with which the response and the decision needs to be made. So I think, the feedback that we got from the previous witness about having an expedited process in statute probably makes some sense, so that it's clear that it's not just one department that can do that, or, so that is a possibility for any of the hearings that come before or any of the cases that come before the Human Services Board, depending upon what the timeliness issues are. So
It's always tricky because you're bumping somebody else. Every
Exactly.
time you're giving one person a legal right, it's bumping somebody else. So if you say 5 days, 3 days, somebody else who had a hearing scheduled that day may not be able to get that hearing that day. And they
Mhm.
might have had that hearing scheduled for
for a long
a
time.
long time.
Yeah, it's tricky.
Can I make two final observations?
Yes, thank you.
Yeah, sure. So I've noticed over the past 14 years, as I've been with Dale, that these fair hearings have become much more complicated. I think as we're talking about all of the motions and all the legalese that's being used, I remember a time when fair hearings used to be, a half a day at most. Every once in a while, there would be one that would go into a second day, but that almost seems to be the rule these days, where we have motions for summary judgment, motions to dismiss. We have multiple witnesses across multiple days, and I don't know what the reason is for that. I've gone to national conferences and I've talked to other folks who have had fair hearings. Their fair hearings are occurring by telephone. They're happening, within a couple of hours. They're able to resolve them. It seems like that may be something that we might want to explore as to why some of these matters are being, why they're taking so long, and why there are so many status conferences, so many motions. That's something that I've noticed over the years. The other thing is, as we talk about an expedited process, I think one of the things we have to realize is that that will require probably more resources.
Mhm.
You know, if right now there is an expedited appeal process, there is a threshold that has to be met in order to be entitled to an expedited appeal. If we are expanding that definition or allowing there to be a more expedited process, I think we need to think about what's the impact on the resources at the department level, at you know, the decision maker level, the board's capacity to review findings of fact after a hearing officer drafts them and submits them. So I think that there's a systemic impact of making that kind of a change. Not to say that that wouldn't be of value to explore, but I think that that's something that that should be considered if we're going to change the process.
Thank you. And, you know, your first point, I think, is what Representative Garofano was referring to earlier when she was speaking of a sort of a process evaluation, you know, really looking at each step of how this is going forward, because that's one of the complaints that we've received, is that, you know, these cases can and I will say that these are in Dale cases, can go on for extended periods of time, and you know, like why? And really sort of understanding what should be happening at the various stages, how long that should take, and recognizing that there's always exceptions to that for various reasons. But if that's becoming more the norm as opposed to the exception, then, you know, I think that's important. You know, I was just looking at the number of cases that you know, that have been heard in 2025. I'll be honest, it didn't seem exorbitant for the number of staff who were there. And yet, you know, people have had some complaints around the timeliness of, you know, being able to get through the process. So thank you both for being here. Yeah, go ahead.
So I mentioned this to the chief hearing officer the other day when we had him in, but I encourage you both also to look into the state's chief performance office, because they have resources that can help different departments, agencies, kind of, you know, have support in doing process maps, finding out where the pressure points are. So it, you know, it would be, I just encourage you to look into that to see what resources are available, because the state does have an infrastructure to help various departments and agencies through these types of performance